I'm at the Equal Employment Opportunity Commission with Chair Andrea Lucas. Thank you so much for doing this interview.
Thank you so much for having me.
You've been running the EEOC differently from your predecessor. One departure you've taken is interest in discrimination cases against white males, particularly. What compelled you to take a closer look at this?
I think it's really important that we demonstrate that our doors are open to everyone. And in the past, frankly, a couple of decades, there's been the misimpression that discrimination law only applied to certain minority groups and not to everyone. But the reality is Title VII has always been colorblind. It's always been group neutral. It's always applied to white men as well as every other iteration of sex and race. But because you've had decades of leaders not making that clear, you really do see that when discrimination arises against white men in particular, there's a real gap in knowledge from employers and from employees. So it was really important that when I saw a lot of discrimination happening in the last few years, really widespread, often DEI-related race or sex discrimination, and then this massive education gap, it was clear to me that we needed to do a lot more public awareness so that those people understood their rights.
Have a lot of white males come forward so far since you put out the call for this?
Well, I can't talk about what has come officially into the commission, but I'll certainly say that, when I issued that public awareness video, we got close to 6 million views and thousands of comments. So there's certainly been a lot of public action that I can, mention. And then to what degree it's turning into actual charges because of Title VII confidentiality, we can't talk about that. But I am confident that based on the public reaction, that's sort of you can just see out there on X, that I think we're achieving what we set out to do, like really raise awareness about people's rights, and that they could reach out to us as a federal agency that's here to help.
As you said, typically we don't think about white males as the top subject of discrimination. Why do you think that's changed over time?
I think that again, it's really a question of what vision are you going to have of the civil rights law? Or is it going to be about a very group-specific, group identity-focused, dealing with quote-unquote historically underrepresented minorities or people of color, BIPOC? Or are you going to have something that is equality-focused, where all discrimination is wrong, and it doesn't matter what race is doing the discriminating or who's being discriminated against? Conservatives have a different vision there, and I think that you had a lot of conservatives not speaking up into that space, and so it was a really one-sided discussion. And when it's a one-sided discussion, it's going to trend towards the left's vision of civil rights, which again is really equity-focused, focused only on the interests of particular groups. So to be clear, I'm not here to defend any specific group. I'm here to say, if you engage in race discrimination, we're going to do something about it. But that also includes groups that I think have been left behind by the prior civil rights leaders.
Maybe an example of this is today you filed a subpoena enforcement action against Nike. What led to this?
Yeah, so this is one of the first public actions that we've taken in DEI-related discrimination. Just to be clear, this isn't a merits lawsuit at this stage. It's a subpoena enforcement action, as you mentioned. But it is based on, as you can see in our public filings, a commissioner's charge that I filed during the Biden administration, which is under investigation. And it's a large-scale systemic discrimination investigation. So typically we can't talk about the work that we do at the investigation stage. We may have any number of things that I can't talk about. But this I can talk about at least a little bit because we did file a subpoena enforcement action, which is something that the commission decided to do after months of attempts to get Nike to comply with our discovery request. So, a thoughtful decision, an unfortunate one that we have to go to court to have someone comply with our discovery request. But once we file in court, we're allowed to talk about the contours of what's in court.
What are some of these practices that Nike has been doing that led to this action?
Well, I can only talk about allegations, but in terms of the things that are alleged in the charge, which again is filed publicly in court, allegations of race restricted programming, so mentoring programs, leadership programs, career development, trainings, again, and you'll see cited in the charge itself, citing specific omissions by the company in public filings and documents that they had published to the SEC, to their investors, on their website, about targets that they set for race-related representation goals, and tying executive compensation to those things as well. So again, the commission hasn't reached any merits decision, but based on the public statements by the company, we had serious concerns and are doing a thorough investigation.
What consequences could Nike face here, depending on how this goes?
Any employer that finds itself at the receiving end of a large-scale systemic investigation is going to potentially have a lot of time and money working through our investigation requests. The EEOC can issue requests for information. We can subpoena information, as we did here, if necessary. We can force the testimony of witnesses, including executive witnesses, if we need to. And that's just in the investigation stage, right? We're going to do a thorough investigation, and this is the federal government, the premier civil rights enforcer saying, you need to speak with us so we can explore what's happened here. And then should we reach a cause determination, a company will have to engage in conciliation with us, which is settlement discussion, possibly a merits lawsuit. Depends on the facts alleged, but it could be thousands to millions of dollars of damages depending on the size of the case. Wow. So it will depend on the specific case. I can't speak to this one in particular, but we have recovered millions of dollars every year, hundreds of millions of dollars every year on behalf of individuals. Another recent thing that just happened today as well. So an example of something that's specific and has actually happened. We just recovered $1.1 million for a class of men who were discriminated against in hiring in a large regional restaurant chain. So an example of one of those $1 million recoveries that we can get for workers.
What message do you think this case sends to other companies who maybe have these alleged DEI hiring practices?
I think the message that we're trying to do more broadly across the board is that under President Trump's leadership, the whole government is really committed to ensuring that everyone's rights are protected and that civil rights are for everyone, and that there's no diversity carve-out to discrimination law. It doesn't matter how you label something. The words DEI don't make something magically, quote unquote, good. There's no good form of race discrimination. It's always wrong, and we're committed to robust enforcement of those laws.
Under your leadership, another topic that you've worked on is the EEOC has rescinded its 2024 enforcement guidance on harassment in the workplace. Why was this change necessary?
So President Trump, when he came in, one of the first things he did was issue the Defending Women executive order. And one of the documents that he identified for rescission was this harassment guidance. While I was a commissioner in the minority in the last administration, I wrote a dissent raising a lot of concerns about that harassment guidance. It had taken the position that basically turned harassment law on its head and said that not only was it not harassment to deny a man access to a woman's space, but that it would be harassment if you didn't let that man into a woman's space, as long as the man, quote unquote, self-identified as a woman. It had no caveats. It had no bounds. It just threw the doors wide open to women's private spaces at work. That troubled me deeply. And I think it was a clear abuse of our substantive, like the limits on our substantive authority. So, between those concerns and the president's executive order, it was time for the commission to take action. And so, at a public meeting, we chose to rescind it.
From the employer's perspective, do you think that employers should be required to make decisions based on the claimed gender identity of their employees? Should that be a factor for them?
I can just only speak on behalf of myself, not the full commission for that point. But, I wholeheartedly stand by the president's positions on this. Biology is not bigotry. While Bostock is the law of the land and we need to comply with that, it doesn't say at any point gender identity in there. And to take the position that women can't actually have their own spaces at work, like locker rooms, changing rooms, bathrooms, showers, lodging places, is the definition of insanity, and it's absolutely not the law, in my opinion. So, I think the courts are going to have to continue to work this out. But from my perspective, I think it's really important to just really have that drumbeat of it's okay to say biology matters, biology is real, biology is not bigotry.
How will this change affect employers on the individual level? What kind of changes should we expect to see, and what consequences would they face if they continue to have these males and female spaces?
Well, to be clear, the commission's not taking a policy position here. It's just rescinding a bad policy from the prior administration. And that's important because, I really believe in being constrained in our authority. We don't have substantive rulemaking authority. Congress, in terms of Title VII, right, which is the primary issue in that particular portion of the guidance, Congress had a really careful, thoughtful, bipartisan compromise in Title VII and decided that Congress, the elected officials, would be the ones who were going to make decisions about sex discrimination and race discrimination, not the EEOC. And so I think it's important for the commission to not be trying to overstep that authority. So while I certainly have my own personal opinions about how harassment law should be shaped, I don't think, in this particular context, we should be issuing guidance documents. How we ultimately handle individual charges that come, I think that's a separate question. I do think that, it's important for women to realize that they could have a claim if they are in a workplace and they find that a male is in their private space. That's something I would take really seriously if someone was to file a charge about that.
What would your advice be to women who have maybe experienced that and are considering filing a claim?
That they potentially have rights. Again, it's going to vary depending on their jurisdiction and how the case law is developing, but they should take seriously the possibility that if they find a man is in their private space, that they may have a harassment claim. We welcome all charges and take them seriously. So they should know that they may have rights. They should consult an attorney. They should consider what they've experienced. And they should feel confident that there's sanity at the federal level who aren't going to gaslight them into thinking that there's something okay with that.
You said the EEOC shouldn't be putting forth this type of guidance in the first place. Does that mean that your EEOC will not be introducing replacement guidance for that 2024 harassment guidance?
Well, I can't necessarily answer that, unfortunately, because I can't speak on behalf of the whole commission. But at least from my perspective, I don't think that we necessarily should be speaking in that area in that particular manner.
How does this change affect religious organizations in particular who believe in two sexes?
Well, they know now that the commission isn't going to be having this policy position out there. Again, the guidance document tried to say that it wasn't binding on employers, but there's, if you look like a duck and you quack like a duck and you walk like a duck, you might be a duck. And that's what, a Texas court found, finding that we were attempting to act like a substantive rule, attempting to act like something that was binding on people. So they should feel comfortable that that is, now actually vacated and removed and rescinded by the commission. Again, they're going to have to continue to look at the applicable law in their particular jurisdiction. But leadership matters, and the tone that the federal government sets from the top matters. The federal government's not going to be actively involved in putting forth this kind of position anymore.
Are there instances which have come up in the past or in your time as chair so far that you believe were examples of people being harmed by that guidance?
There are lots of lawsuits, and other than that, I can't talk specifically about it because it would deal with confidential information.
Something that conservatives have been calling for with the EEOC is changes to the Pregnant Workers Fairness Act's abortion requirements. Particularly, you've written that you supported the original PWFA, but that it's departed from its intended goals. How do you believe that's happened?
I did have a lot of concerns about the final rule. I thoroughly support the Pregnant Workers Fairness Act itself. I advocated for it. I think it's really important for workers to accommodate pregnant women, and it's good for moms and babies. And I know the administration is strongly in support of protecting women and children. But that's distinct from us deciding to rewrite the law that Congress passed, which again was another one of these careful bipartisan compromises. I was concerned with the way that we defined what it meant to be a pregnancy or related medical condition, pregnancy, childbirth, or related medical condition really, just threw the doors open to anything related to that, as opposed to a pregnancy or a childbirth. Ultimately where we go from here, I can't talk about at this stage because I don't want to prejudice any potential future rulemakings. But again, I think it's important for the commission to stay within the lines that Congress actually gave it. And in those lines, there's lots of good work that we can do in this space. We've actually doubled the number of cases in the last year from the last administration in terms of cases on behalf of pregnant and postpartum women, whether it's pregnancy discrimination or pregnancy accommodation. We filed twice as many cases, and we're getting thousands of dollars for pregnant and postpartum women. So I feel really good about what we're doing to support women in the workplace.
What about that definition of pregnancy is your concern in the PWFA?
I mean, just basically that we rewrote it to be something completely unbounded that doesn't actually mean the words that Congress gave us. I know it sounds kind of simple, but it really is actually that simple. We took a term that was pregnancy, childbirth, or related medical conditions and threw the doors open to really anything that could have some sort of nexus related to female reproductive health. That's not, in my opinion, the law that Congress wrote.
Mm-hmm. I see. What could be the path forward here? What are some of the, just potentially, what could change here?
I wish I could talk more about that, but because, I don't want to prejudice potential rulemaking, I can't get into that.
And you said the rule in its current form is too broad. This definition of pregnancy and other related conditions encompasses so many things. What impacts can this have on employers bound by this law, bound by this rule?
Yeah, again, to the extent that it's going beyond what Congress intended, it can create a burden that someone would need to accommodate something that Congress didn't intend. Thus far, I don't think that we've thankfully had too many examples of that. Again, the commission has dealt with some lawsuits, and those have been settled with the groups that are concerned about overreach at that point. But in terms of the kind of enforcement work we're focused on, we're really focused on applying it the way that Congress intended and protecting pregnant women and recently postpartum women. I certainly recognize the concerns of groups, but I think that so far, based on the decisions in court that have vacated some of the specific issues related to abortion, as of now, those groups, they have a good path to protect their rights.
What would you say to those groups who are concerned about having to cover abortion or IVF or other things they might not agree with?
Again, I think that if you have concerns about how it might be specifically applied to you, you always have legal options to potentially sue related to that. I can't speak to any specific situation because it'll really vary, but people always have the option to evaluate their legal options if they have concerns about something is being applied to them in particular. It's going to be too variable for me to say anything more than that.
But you said the EEOC would be applying the original congressional law rather than kind of some of those changes we've seen?
Well, at this point, the portions that relate to abortion-related accommodations have been vacated by a court, so we're going to comply with that court order, which at that point brings us, I think, much closer to where Congress set forth. Again, though, to the extent that the rule remains, portions that aren't vacated, we are bound by that. That's what the commission voted on. That's in the Federal Register. But the portions I think that many groups have been concerned about related to abortion-related accommodations, there have been some legal actions that have restricted our actions there. Again, it'll depend on the jurisdiction and the scope. I don't want to get too much into all the details, but you should just consult our website to see where there have been limitations based on court orders.
I believe you've said in the past fertility accommodations may not fall under the purview of the PWFA's intent. Why is that?
Again, it's that's going to be just a question of whether or not you define pregnancy, childbirth, and related medical conditions to expand to fertility issues, but it's going to vary depending on the specifics of that. Again, that's my own personal opinion. As of that time, the commission ultimately, to the extent that it wants to revisit this, we'll have to revisit that in a collective manner. So I don't, again, want to prejudge any rulemaking.
Is there anything else about the PWFA that you would like for people to know, or about your view there?
I mean, again, I know that there's been focuses on some of the controversial parts, but I think the message that I'd like people to take away is that there's lots that is good about it. And, I think that all three of the commissioners currently are really supportive of protecting pregnant women and really enthusiastic about that. This is an administration that cares deeply about family formation and supporting families and mothers. And so I think that's really the message that people should focus on, not on some specific application points, which at this point are being worked out in the courts.
And there was a recent New York Times article about your work at the EEOC. A former chair named Jenny Yang told the New York Times, "What we're seeing now is a real politicization of the priorities of the agency and a disregard for the law." What would your response be to that?
I mean, my response would be that Republicans don't just have to sit and ignore policy positions, right? Democrats have done whatever they liked with the agency over the various decades, but it can't be that only Democrats get to have policy positions or enforcement positions or policy priorities. The American people elected the president, and we are an executive branch agency, and we are going to be responsive to that. We're not an independent agency, and so the EEOC is going to be responsive to policy positions that's completely appropriate. When a Democrat is in power, they will do with the agency as they will, but right now we have a Republican president, and we're going to execute his priorities. And also, conservatives can have a unique vision of civil rights law, and I would argue against anyone that our view is a better, more moral one that says that people are created equal and there's no good form of discrimination, and we're not just going to pick and choose winners and losers related to race discrimination. We're going to say every form of race discrimination is wrong. Again, I said that in that article, but I just think that that's a much better, more beautiful view of the world, and the view that leftists have advocated sometimes through the EEOC, that the remedy to past discrimination is future discrimination or present discrimination. That's a really ugly view of the world that I don't want for my kids, and it's a privilege to be able to fight back against that at the EEOC.
It seems like you said that your EEOC is not an independent agency. It seems like your view of the EEOC is different than some past chairs. How would you describe how your philosophy is different?
I would describe their philosophy as hypocritical because all of them know and have known for decades that we're not an independent agency. For decades, since the late 70s when we retained authority over the Age Discrimination and Employment Act, it's been very clear that we're an executive branch agency. They haven't wanted to message that, but that's been the reality. And so I would say that my view is consistent with decades of precedent. It's just never been really, I think, as well messaged. And I think that this is one of the first Republican administrations to really thoroughly say, yeah, this is the law, this is the correct view of the world, and we're going to be responsive to the will of the American public.
Do you believe that this will have a long-term effect on how future chairs view the EEOC?
I hope so. My goal is complete and absolute reform of the agency to go back to principles that were good and right in the early part of the civil rights movement, to this grand bipartisan compromise to stamp out discrimination and to do it in a colorblind, group-neutral way. I hope that we can achieve, substantial reform of the agency during my time.
What are your priorities for 2026 as far as those total absolute reforms go?
Across the board, operationally, we're really just trying to make it a really efficient agency. And there's lots of stuff that we're doing under the hood that I think will help us be more responsive to the public and better able to handle a really high volume of charges, a lot of outreach work. But substantively, again, combating all forms of race discrimination, including when it arises from DEI programs is one of them. Pushing back against gender ideology and defending women's rights is another. Protecting the rights of American workers, again, American workers of every race, to be free from national origin discrimination that preferences foreign workers over them. And then protecting religious liberty, which is a first freedom and not a second class right. The Commission's got a lot of authority there, and we've already recovered millions of dollars for religious plaintiffs in my time so far.
A little bit more about what you said about protecting Americans who have lost jobs potentially to foreign workers. Could you tell me a little bit about your work with Project Firewall to make sure that American workers have equal opportunities?
Yeah, it's a really exciting initiative. It's a whole of government, but it's led by DOL. We're excited to partner with them. American workers is the centerpiece of President Trump's agenda here, and really protecting all Americans from the right to be free from discrimination. And that includes when companies want to prefer foreign workers. So it can come up in a lot of different ways. Project Firewall is particularly focused on H-1B related issues. But there are other iterations of that. We see it when a company that might have been, launched in another country comes to our country and decides to open locations here. They may not realize that it's not acceptable to have all of their executives or most of their employees be from their sort of home country. That's unlawful. We see it in farm workers or frontline workers where people will try to segregate workplaces and only hire Hispanic workers, perhaps because they think that they're going to be either illegal aliens or monolingual and therefore more vulnerable. So, it can come up in really almost every workplace, from really white collar tech companies to, frontline service industries, manufacturing. We're interested in all of them, and we're going to just protect a whole host of American workers.
What about situations where employers are potentially listing jobs only to foreign workers? Americans aren't able to see those listings. What can be done about that?
Yeah, so Title VII actually has a specific provision about discriminatory job ads, and that alone is a violation of the Act. So I'm really hopeful that we're going to be able to have some public action soon that will push back against that. Hiring discrimination is often hard for people to prove, but we find so often there are these just facially discriminatory job ads. So we're definitely going to be clamping down on that. And hopefully just doing more education too for employers to understand that that's not acceptable.
How frequently do you think this is happening?
I think it's rampant. I think that this is a really, really big problem. And it's another example of where, because there's just been lopsided discussion about what the law covers, most people understand that you can't discriminate against a foreign worker, but they don't understand that American workers can constitute a national origin. So it's one of those things where discrimination is happening in plain sight, and people just don't understand their rights. So we're really trying to push back and educate people. But I think it is a really major problem.
Did the Biden administration do anything about the type of discrimination, the previous?
Not nearly enough. Some, right? The agency actually has a pattern over several different administrations of recovering millions of dollars for American workers. But I do think we're only just scratching the surface so far. Thus far we've had a couple, we've had one big $1 million+ recovery for something that was launched in the Biden administration and then came to fruition in the Trump administration, involving preference for Japanese chefs and a location in Guam, which is American territory, and American workers were harmed there. You see bits and pieces, but I think the level of H-1B related enforcement, we're really just scratching the surface. There's a lot more to be done, and I'm really encouraged by the whole of government effort that Project Firewall involves.
Sounds like this really has the potential to change the H-1B program as we know it.
That's the goal.
Well, thank you so much for your time today. I really appreciate it.
Thank you. It's a pleasure to speak with you.